change for the U.S., turning a blind eye to other politically sensitive issues. This is SRN News.
Odyssey.
Depending on where you are, you can pick up Faith Talk Radio on the FM dial. If you're on holiday to St. Petersburg or from Brandon to the coast, listen to all your favorite Faith Talk programming on FM 100.3. Strength between Sundays, always on AM 570 and online at letstalkfaith.com. And in Northwest Hillsborough County on FM 100.3.
Are you a caring person with a heart for helping others? Do you volunteer your time to check in on seniors from your church or run errands for homebound neighbors? Why not earn additional income doing exactly what you already do in your community? Seniors Helping Seniors is hiring mature, active adults in Hillsborough and Pinellas to help less active seniors in their homes. Earn additional income doing what you love. Learn more when you visit 813seniors.com. That's 813seniors.com.
Strength between Sundays. Faith Talk 570 and 910. Online at letstalkfaith.com. The following program is sponsored by the law offices of Patrick L. Smith. This is the Attorney Patrick Smith Show. Get ready with your legal questions and call Patrick now. 877-943-9673. Again, that's 877-943-9673. The law office is open. And now your host, Patrick Smith.
Oh, hi there. I'm Attorney Patrick Smith, and you're listening to the Attorney Patrick Smith Show. Today is Saturday, November 13th, and we will be with you for the next hour to answer your legal questions. The number to be part of our program, back to our regular number, 877-943-9673. After a little maintenance, now supercharged and ready to take on your calls, 877-943-9673. You can give us a call now. We're live and local. Open phone lines will get you and your call right on the air. 877-943-9673. You can email your question, Patrick at attorneypatricksmith.com. Patrick at attorneypatricksmith.com. For those of you new to the show and who may not know about me, I'm local Central Florida attorney Patrick Smith. I've been in practice here for over 15 years now and thousands of clients throughout the Central Florida area. Primary practice area is estate planning, wills, trust, asset protection. But throughout the years, I've worked with attorneys on various other cases in different fields, so familiar with lots of areas of law. And our promise to you here on the Attorney Patrick Smith Show is if we don't have the best answer, or sometimes we just don't know, we will always promise to put you in touch with someone that does. In the meantime, you can call in and ask your question on any legal topic. Maybe it's a landlord-tenant matter. Maybe it's a real estate matter. Maybe it is regarding family law, personal injury, Medicaid, estate planning. Any topic at all, we'll be happy to help you as best we can and give you a little peace of mind. And we encourage you to call in because, number one, like I always say, the first caller often sets the trend for the show, and your call is going to help a lot of other people out there. There's a lot of people listening right now that have heavy legal issues weighing on their mind, and maybe your call and question and everyone else hearing my answer will give everyone some peace of mind this morning. So 877-943-9673, 877-943-9673. That's your toll-free number. You can also email your question, Patrick at attorneypatricksmith.com. Again, Patrick at attorneypatricksmith.com, or give us a call now, live and local. Open phone lines, 877-943-9673. So I wanted to delve into the first topic this morning, which actually concluded a speaking engagement I was doing yesterday. As the Q&A session was winding down, the very last question that popped up was, would you mind explaining Florida homestead law? And of all the questions to pop up for the last question, when you have about 2 minutes left, and you hit on a topic that's probably the number one most misunderstood topic in the state of Florida, I told the gentleman in the audience who asked, I said, I'll do the best I can with 2 minutes, but tune into the show tomorrow, and I'll talk about homestead law in between calls, which, by the way, we are taking your calls. So if you want to call in, 877-943-9673. 9673, 877-943-9673. Nevertheless, to make good on my promise, I said I would start the show with a discussion on Florida homestead law, and here we go. So a lot of people have misconception about what Florida homestead law is, and a misunderstanding where the misunderstanding is because it is too limited. Oftentimes people, and this is about the time of year when people become keenly aware of what most people consider the totality of homestead law, because you get your property tax bill in the mail. And for those of you who have a homestead exemption on your property, you're getting a break on that first $50,000 that's tax-free because it is your homesteaded property, and that's under Florida Statute 196. That's your primary residence of which you have a present possessory interest, so you get this break on your property taxes. Now, for most people, that starts and stops their homestead law knowledge. And the homestead law goes so much further than that, and that's where a lot of the bear traps are. It seems deceptively simple because of the property tax components, but homestead law at a minimum is really a trilogy. There's really three parts to this. The first part is, of course, the property tax component. The next two parts regard constitutional creditor protection and then devise restrictions. So restrictions on how you can devise your homestead property. There's rules about situations and scenarios where you're not necessarily free and clear to devise your homestead property to just anyone. So if you have a question, 877-943-9673, 877-943-9673, and your question can be on homestead, or maybe it's not on homestead, maybe it's on a different legal topic. We'll be happy to help you any way we can this morning. 877-943-9673, or email your question, patrick@attorneypatricksmith.com, patrick@attorneypatricksmith.com, or give us a call now, 877-943-9673. So let's talk about the second prong of Florida homestead, the constitutional creditor protection. This is Article 10, Section 4 of the state constitution. When a lot of out-of-state attorneys scour Florida statutes looking for the creditor protection provisions, they don't find it. And the reason they don't find it is it doesn't exist in any statute. It exists in our state constitution, Article 10, Section 4. So Article 10, Section 4 of our state constitution says that your homestead property is creditor protected from any creditor claims, so long as it meets certain geographic requirements. 1/2 acre within the city limits and up to 160 acres outside of the city limits. Now notice, there's no economic cap. There's no value cap. It's a geographic cap. And it really goes back to Florida's agrarian history and ancestry. As far as the cap being 160 acres outside of the city limits, you can probably guess why. That was to protect farmers, and 1/2 acre within the city limits protecting business interests. And at the end of the day, there was no value on this, no value cap. It could be worth anything. It was just a matter of geographically it was capped. 1/2 acre within the city limits, 160 acres outside of the city limits. And this property was protected from creditor claims because public policy in Florida was we thought it was a good idea that people don't lose their homes. Now, there's two exceptions to the constitutional creditor protection aspect of homestead. Number one is, of course, if you don't pay your property taxes, and number two is what we call a mechanic's lien. If you pay or if you have someone come on your property to do an improvement, like install a pool or something, and you don't pay that person, they can file what we call a mechanic's lien. But absent those two exceptions, your home can be constitutionally protected here in the great state of Florida. So not under any statute, but under the highest body of law in this state, our Constitution, it will protect it. 877-943-9673. That's your live and local number to call in now. 877-943-9673. Or email patrick@attorneypatricksmith.com. patrick@attorneypatricksmith.com. Or give us a call now, live and local, open phone lines. We'll get you and your question right on the air, 877-943-9673. Again, 877-943-9673. So that is the constitutional creditor protection component of homestead law. Now, let's talk about the third and final prong of homestead, devise restrictions. Let's talk about the one that's least popular first, the one with regard to minors. So if you own a property in just your name and you have a minor child, then there are certain devise restrictions. You can't just devise that property to anyone because of the minor child. Now, there's an exception here if it's a married couple who owns the property, husband and wife. So there's an exception for that. For many people, that hollows out the overall rule. But if you're a single parent with a minor child, be aware that there's going to be restrictions on how you can devise that homestead property. But the bigger bear trap here, the one we see much more frequently, is with regard to the spousal restrictions. So here is the spousal restrictions on Florida devise of Florida homestead property. So let's say we have a widow and a widower who meet at a bereavement or grief counseling session, and they decide to enter into a second marriage after the passing of their first spouse. The husband has a property in just his name that's his primary residence. He says, I do, and gets married, and had done all his estate planning with his former spouse. So they had a joint trust set up, the home was in the joint trust, and everything was left 50-50 to his two boys. He remarries, he enters the great beyond. When he does so, does the property pass to his two children? The answer is not entirely. Why? Because there were spousal rights to that homestead property. Indeed, these spousal rights actually even exist inter vivos, or while the person's still living, to demonstrate that. And some of you, this is going to make a lot of sense to something that's confused you for a very long time. If you are married and the property, the primary homestead property, is in your name alone, and you went through a refinance or a sale, and they insisted on your spouse joining in the conveyance, that's because of the state constitution. Article 10, Section 4, subsection C, says it in the affirmative. You may transfer homestead property with spousal joinder, but it's the converse that really demonstrates the rule. It's you may not transfer it without the spousal joinder. So even while you're alive, to transfer homestead property, if you're married, even though the property is in just your name, your spouse's signature and joinder is going to be required. But if you've passed, now what rights does the spouse have to the property? Now the spouse has the right to live in that house the rest of their life. And prior to 2010, that was it. After 2010, there was an amendment because of some great legislation that came down the pike from some wonderful lawyering out of South Florida. And this amendment said the spouse is now given the right to make an election, what we call a tenant in common election, or a TIC election, where they can take a 1/2 interest in the property right away. And they have to make this election within 6 months of the date of death. Now, this is 6 months of date of death, not 6 months from when the administration begins. That is a bear trap. Do not step in that if you're a practicing attorney in this field. It is 6 months from the date of death. And it's irrevocable. Once the spouse makes the selection, they give up the life estate, they take half the value. So in our prior example, the dad who had the home in his trust for his two boys, he passes. Now all of a sudden that surviving stepmother can elect to take half the value of the home away because of the spousal homestead rights. Those can all be adequately addressed with what we call a knowing waiver under 732-702, and that's usually codified in something called a prenuptial or a postnuptial agreement. But that is a cursory analysis of what we call Florida homestead law. And you see why when I was asked about it with about 2 minutes to go, I kind of cringed because I didn't have anywhere near enough time to sort of unpack the question. But if you have a question this morning, 877-943-9673. Give us a call. We're live and local. And then your question can be on homestead. I know we started with sort of a dense conversation on homestead. We're happy to answer your homestead questions or any other legal topic, 877-943-9673, or email your question, patrick@attorneypatricksmith.com. Let's go to Sarasota and let's talk to William. William, welcome to the Attorney Patrick Smith Show.
This is Lance from Sarasota.
Oh, Lance. Lance, our apologies.
Yeah, no problem. I got a question about homestead. If your house is homestead, do you have a cap of how much taxes will go up per year on homestead. I heard that is true, but I don't really know the answer to that.
Yeah, there is I believe it's currently set at 3%. It's under the Save Our Homes Act. There is a cap, and people are discovering now, this is the hard way when people discover that their property has not been properly homesteaded, especially in a real estate market as hot as this one is, because people who neglected to put their homestead exemption on the property, their property taxes skyrocketed this last year because, as you know, Florida real estate is super hot right now. So, absolutely getting that home, that's another component. And you see, again, homestead is just such a convoluted and dense. I keep going back to that word, Lance, but that's the best word to describe it, because in Florida, we really have Florida real property law, and then we have homestead law. And woe unto anyone who treats homestead property as if it's any other piece of property. It is very tricky, and you have to make sure that if you have these homestead rights, that you continue to maintain those homestead rights, or if you don't have those homestead rights, then you go and file the appropriate paperwork to make those elections so that you get advantage of Save Our Homes and things of that nature.
I have one more question.
Yeah, go ahead, Lance.
If you're a homestead and you decide that you want to VRBO or Airbnb, my understanding that you can get docked a little bit on taxes or your homestead percentages if you rent out your place from time to time.
Yeah, that's a great question. So here, again, to further unpack homestead, in the state of Florida, the homestead property by definition has to be your primary residence. So Lance, usually this question comes up with, well, what if mom or dad are going to be in a memory care facility, or if they're going to be in a hospital for an extended stay? Current case law in Florida says mere abandonment of the homestead property is not a forfeiture of the homestead rights. So just because mom and dad aren't living there, that's not going to affect their constitutional creditor protection. Your question about, now I'm renting it out, I'm doing a VRBO on it, or an Airbnb on it, you're going to lose at least part or probably all of your homestead exemption. And why? Because if you're renting it out, how can it be your primary residence?
Mm-hmm.
Unless these people you're renting it out to are living with you, which would be weird. But I guess you could do that. But it's still, I think you probably lose part or potentially all of your homestead exemption there because of the fact that it's no longer your primary residence.
Yeah, I understand. That's what I thought.
Yeah.
Thank you very much.
Lance, you're most welcome. I appreciate you calling in.
You bet. Thanks.
All right. This is the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. 877-943-9673. That's your live and local number to be part of today's program. Open phone lines. Get you and your question right on the air, just like Lance made it look. It's that easy. Call in 877-943-9673. 877-943-9673. Encourage you to call in now with your question, and you can email your question, patrick@attorneypatricksmith.com, patrick@attorneypatricksmith.com. To follow up to Lance's question about the VRBO and what if I rent it out, sort of the flip side of that coin, and Lance's question being, does that expose me to a loss of my homestead exemption, which it potentially does, by the way. What are some other things you can do with homestead that could potentially cost you a homestead exemption? The one I see most commonly is when clients are seeking to add a child's name to their home. Now, there's lots of risk with doing that, liability, gift tax, all kinds of things. But if your child already has their own home on which they're taking a homestead exemption, you can't take two homestead exemptions. So now the child being added to the parent's house is going to lead to at least a partial loss of homestead on that property. So that's a common reason why we don't add children's names to property, in addition to the gift taxes and the liability exposure and the loss of step-up in basis. But as you're getting a sense, Florida homestead is one of these things that sort of permeates throughout the state of Florida in lots of different ways, and it's something you have to be keenly aware of. And I think the property tax bill we get every year is always my reminder that it's a good idea to start talking about it at seminars and here on the radio shows. So if you have a homestead question, feel free to call in. Or if you just have a question on any legal topic, 877-943-9673, 877-943-9673. You can call in now, and we are live and local. Happy to help any way we can. You can email your question, Patrick at attorneypatricksmith.com. Again, you can email your question to me during the show or throughout the week, Patrick at attorneypatricksmith.com, or give us a call now. We're live and local, 877-943-9673, 877-943-9673. All right, to reach us at the law office throughout the week, whether you want to meet us in the Sun City Center office, which, by the way, what a way to be welcomed there in Sun City Center. You know, the Pant Wealth Management Group, the way they have welcomed us, and the family there that is Sun Radio at 96.3, Kim and Peter and Bern and the whole gang down there, just making us feel so welcome down there. We appreciate you guys so much. If you want to meet with us there in the Sun City Center office, you can do so by calling the toll-free number 877-754-6764, 877-754-6764. That's also the same number to reach our Pinellas County office. You can schedule at Pinellas here in beautiful Seminole, Florida, 877-754-6764. Or you can visit the website, attorneypatricksmith.com, or give us a call now, 877-943-9673. 877-943-9673, or email your question, Patrick at attorneypatricksmith.com. All right, let's go to Clearwater and let's talk to Carol. Carol, welcome to the Attorney Patrick Smith Show.
Good morning, Patrick.
Good morning, Carol.
I'm calling because I was just listening to you about property tax and homestead.
Yes, ma'am.
I'm older. I've lived in my home 22 years, and I'm going to say a living trust, for my children, and my house, my condo is in it. Am I still getting homestead? Or does that interfere anyway with homestead?
More than likely, no, Carol. If your documents were properly prepared by an attorney, then the homestead exemption should be protected and continuous, and I'll demonstrate this for you. Okay, so did I do your documents, Carol, by chance?
No, you did not.
Okay, so when I do a client's documents, here's how I typically treat the homestead property. Okay, I usually put in the deed conveying the property to the trust language, special language, sort of the secret sauce, that indicates this is homestead property. But then I go one step further, and within the trust, I indicate that the property flowing in is going to be homestead property. And this trust is designed to hold homestead property. Now, why take those extra steps? That way, the Carols of the world who have been in a home for 22 years with a homestead exemption on the property don't have to reapply for homestead and risk the property being reevaluated. So at the end of the day, you can maintain a continuous flow of your existing homestead exemption. The attorney just has to take a couple extra steps in drafting that.
Okay.
And if you want someone to look at that free of charge, either call your attorney or call us. We'll give you a complimentary review, Carol, just to give you peace of mind that that is the way we think it is, okay?
Thank you very much.
Thank you, Carol. All righty, this is the Attorney Patrick Smith Show, and I'm Attorney Patrick Smith. You can give us a call now, 877-943-9673, 877-943-9673, or email your question, Patrick at attorneypatricksmith.com. Again, you can email your question, Patrick at attorneypatricksmith.com, or give us a call now, 877-943-9673. All right, let's go to Sarasota and let's talk to Bob. Bob, welcome to the Attorney Patrick Smith Show. Hey, Bob, are you there?
Hello?
Hey, Bob, can we get you to turn down your
Can't
radio?
hear you.
Yeah, can we get you to turn down your radio a skosh?
Hello? Hello?
Hey, Bob,
Hello?
we're going to let you go, and you can call back, Bob. We'll try another connection. All righty. So 877-943-9673. That's your live and local number to be part of today's show. 877-943-9673 or Patrick at attorneypatricksmith.com. All right, let's go to beautiful Kissimmee, Florida, and let's talk to Sophia. Sophia, welcome to the Attorney Patrick Smith Show.
Good morning, Mr. Patrick. How are you?
I'm great, Sophia. How can I help you?
It's regarding an injunction.
Avoiding one or implementing one?
It's actually been implemented.
Okay. Tell me what's going on, Sophia.
Okay, my husband filed an injunction against me. He went to Jamaica and came back from Jamaica September 22nd. Left the home October 4th. Hadn't heard from him. I've called, I've texted, I've messaged, no response. November 9th, I heard banging on my door. Come to find out he filed an injunction against me. The sheriff came to serve me, and eventually they got me out of my home, and now he's in the home. In the injunction, it said that I'm an alcoholic. I choked him on September 22nd. I jumped on him. I threatened him. We tried calling the police, and now I'm out of my home with my 2 girls.
Wow. I'm so sorry to hear that, Sophia. The type of attorney you need to speak to is a family law attorney. And I work with an absolutely fantastic one. He's of counsel with me, and I'll be happy to put you in touch with him on Monday. I'll give out the main office line here in a moment, Sophia, so if you want to get ready to write it down, give me a call at the office on Monday. I'll be back in the office at 8 a.m. I'll make sure to get in touch with you and get you in touch with the attorney and get you squared away with it. This is in Osceola County, correct?
Correct.
Yeah, we'll get you squared away with everything you need, Sophia, and you and your girls and your former husband, you're all in our thoughts and prayers. I'm so sorry about that situation.
Thank you, sir.
All right, God bless you, Sophia.
Thank you.
All righty. 877-943-9673. That's your live and local number to be part of today's show. This is the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. That number to reach me at the office during the week, by the way, Sophia, or anyone else who wants to, 877-754-6764. 877-754-6764. All righty, let's go to Palm Harbor and talk to Andrew. Andrew, welcome to the Attorney Patrick Smith Show. Good morning, Andrew.
Hello?
Hey, Andrew, there you are. Andrew, we can hear you. Can you hear us?
Hello?
Hey, Andrew.
Hello?
Andrew, can you hear us?
I can hear you now.
All right. Success.
How you guys doing today?
We're doing okay, Andrew. The phones have been a little smoother before, but that's okay. We're getting through it. How can we help Andrew today? We appreciate your persistence.
I have a question. I have 3 properties. They're all in the same court. I live in mine that I've lived in for 35 years. My daughter lives in the one next door, and my son lives in the one next door to that. Now, is there any way that I can, without putting the houses under their name, save on these taxes? Because it's like they're rental properties and I'm paying outrageous taxes on them with my kids living there.
Well, if you combined all 3 properties under one deed, so if you had it resurveyed, so to speak, would the combined 3 lots be less than half an acre?
It's a good possibility.
Okay. And are you within the city limits or are you in the unincorporated county?
Unincorporated.
Okay, so you're good up to 160. So I think the short answer is, if you can get it reconfigured so it's under one deed as opposed to 3 separate parcels, and then say this is just one big property that's all mine, and I'm happy to share it with a couple of family members, I think you could be in good shape there.
No kidding. Boy, that's great. That's real great to know. I didn't know if I had to put them in a trust, but that would still cost me taxes and everything else.
Yeah, I don't think the trust is going to be your solution because I still think that's going to show that you own 3 separate parcels. I think it's a matter of reconfiguring it with the county to say, hey, these 3 parcels are now going to be basically undivided and basically put back under one parcel. And you would just have it surveyed, and you would want to know all that ahead of time. But I think that would be the process to do that.
And then, now, what would happen if I was to die and I wanted to leave these properties individually to, each separate child?
Well, now the trust comes into play, and you're right about that. So that's where, when you have it surveyed, you have those legal descriptions of sort of the separate lots. Even though you're combining them, you would basically say, upon my passing, it's to be re-subdivided into these separate sections, and you could do that.
Oh, wow, that's interesting. I guess I need to get your phone number and get back in touch with you and take care of this.
Andrew, we'll give out the number here in just a moment, okay?
It sounds great. Thank
All
you
right.
for your help.
Thank you for calling in. All right, this is the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith, 877-943-9673, 877-943-9673. That's your live and local number to be part of today's program, 877-943-9673, or email me, patrick@attorneypatricksmith.com, patrick@attorneypatricksmith.com. That law office number to reach me at the office during the week, to set up your complimentary consultation or just to speak to me, 877-754-6764. Again, 877-754-6764. All right, let's go to Sarasota and talk to Bill. Bill, welcome to the Attorney Patrick Smith Show.
Hi, Patrick. Got a question for you. Had a family friend yesterday, got a DUI, and I guess first on the ticket it says at the end of December that they have to be in court. Now, when they go, if they plead guilty to that, do they put him in jail right away? How does that work?
You said this, he got a DUI. Is this his first DUI?
Yeah.
So first DUI, likelihood of him going to jail, probably not very high. It's possible. Has he hired a criminal defense attorney yet?
No, because this was just 2 days ago.
Yeah, and it's is it near the Sarasota area?
Yes, yep. It's in the Sarasota area, and there was no, it was just a stop. There was no damage or, didn't hit anybody else.
Well, praise God for that. So, yeah, I've got an attorney. It's actually a good buddy of mine from high school who's actually a practicing attorney over here in Pinellas and Sarasota. And I'll be happy to put you in touch with him, and you guys can get your buddy in touch with him, and I'll give out the office number here in a moment, and you can give us a call at the office, and we'll make sure that he speaks to the attorney, and hopefully they can get some sort of notice of appearance filed, and then sort of get your friend out of this situation, and hopefully he's learned his lesson and never has one of these again.
I know, and I sure hope so. I'm so happy that nothing happened with anybody. So,
well,
thank you so much.
That's a split-second decision where it can have permanent consequences. And like you said, your buddy was very fortunate that neither he nor anyone else was hurt.
Yeah. So I'll write the number down when you have it,
Yep.
and that'll be for your office, or would that be for your?
No, this will be
friend?
this will be for my office, and I'll give you a referral to the attorney, and I'll even call him and give him a kind of little heads up on the case, and when I get a little more information about the background. Okay.
Okay, sounds good. Thank you.
All right, thank you, Bill. All righty, you're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith, 877-943-9673, 877-943-9673. Again, you can email me throughout the week, patrick@attorneypatricksmith.com, patrick@attorneypatricksmith.com. And that office number to reach us at the law office throughout the week for any of the office locations, toll-free number, 877-754-6764. 877-754-6764. All right, let's go back to Sarasota. This time, let's talk to Nick. Nick, welcome to the Attorney Patrick Smith Show.
Hi, Patrick. Hi. It's a homestead question. It's my primary resident, and during COVID, I brought a friend in that I was renting out one of the rooms to, and they hit me with a $1,000 tax bill for having one room rented out. Have you ever heard of that before?
Yes. So, again, this goes back to the question we had earlier, where it's a situation where if part of that property can be shown to not be your primary residence, like you're renting part of it out, you run the risk of this exposure. So, yeah, Nick, that you played with fire and you got burned. I mean, that's a situation where if you're going to rent the property out, then by definition, it's not your primary residence.
I live there. I only rented one room out.
Yeah, and that's why they probably didn't take away your entire homestead exemption. They took away a portion, I'm guessing, correct?
Right.
Yeah.
I believe that's what they did. It was I had to pay them $1,000.
I mean, you can dispute it, and you can go and have your hearing with the county and kind of make your case if you'd like. But, I mean, is it an immediate family member?
No.
All right, and they are paying you real dollars for the room.
Well, yeah, he owes me. I mean, it was part of the rent paid and not part of the rent paid. You know, it was one of those situations.
So at the end of the day, if you're collecting money, it sounds like a landlord-tenant deal to me. And if you're leasing out part of the homestead property, then by definition, it's not your primary residence for at least that portion, Nick.
Right, that's what I understand. I have one other question on HOA.
Sure.
I've had a dispute with them for years, and they've tried to hire 3 or 4 law firms, 3 of which dropped out because I told them it's a conflict of interest. They destroyed part of my property when they hired a contractor to put in some of the stuff, and they took my fence down, and then the fence was stolen by the contractor workers. So when I went in the beginning, it was mediation. This was years ago. Well, I kind of won the mediation because the mediator said, you guys need to figure this out, and he's got a good claim. You know, I showed him pictures. I had everything documented, and they wouldn't do anything. You know, I tried to contact them. They wanted to hear it, you know. And so I'm like, well, I'm not paying my HOA fee until you settle this dispute with me. So they finally got another law firm in there, and this has been going on for another year or 2. And, of course, they're threatening me with foreclosure on my house if I don't pay the HOA bills.
My initial advice, Nick, is to get current on your HOA bills because I doubt there's anything in your HOA bylaws that say, well, if you have a dispute with us, then you can stop paying your HOA dues. I think that you may very well have a valid cause of action or grievance against your HOA, but I don't think that exculpates you from paying your HOA dues. It's kind of like if you had a dispute with a landlord-tenant. Let's say your landlord isn't fixing your air conditioner fast enough or isn't fixing something else fast enough, the range or something of that nature.
Right.
That doesn't mean you don't have to pay them rent the next month. It just means you have a cause of action against them under the covenant of quiet enjoyment or something, some sort of breach under the lease. So, in other words, it goes back to kindergarten. You know, 2 wrongs don't make a right. If they're doing you wrong, you doing something wrong back to them doesn't give you justification. So I say get current on your HOA, get with a good attorney, and get your cause of action before a judge and get the judge's ruling on it.
Okay, but get current on the HOA, huh? Because it goes back like 10 years.
Yeah, unless you have in black and white saying because they did what they did to you, it exculpates you from paying your HOA. And I doubt you're going to find anything like that in there because the HOA lawyers wrote these bylaws. But if you do, I mean, by all means. But at the end of the day, I think you need to play by the rules. Go after them for the cause of action you have, and don't do this sort of self-justice where you try to just get them by not paying your HOA. And all you're doing there is handing them a freebie. I mean, you're handing them the ability to foreclose against you, and you don't want that.
Right. Okay. All right. That's what I'll do, I guess.
All right. Well, good luck to you, Nick. Okay.
All right. Thank you, Patrick.
You're welcome. All righty, this is the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. You can give us a call now. We're live and local, 877-943-9673, 877-943-9673, or email your question, patrick@attorneypatricksmith.com. All right, let's go to Lakewood Ranch, and let's talk to Jeff. Jeff, welcome to the Attorney Patrick Smith Show.
Good morning, Mr. Smith. I
Hey,
have
Jeff.
a question about homestead portability.
Yeah, good question.
If we're living in our home for maybe 20 years and we have a homestead exemption, and our taxes now are significantly lower than someone coming in on our street buying new, and we want to move to another area in Florida, how does that portability work if we go to an area somewhere else in the state?
So I actually just went through this about 2 years ago. So my wife and I built a home in beautiful Indian Rocks Beach, and we're selling another home. And we had been in this other home, I don't know, probably 13 or 14 years, and had a homestead exemption on it. And there is some sort of formula. So you don't lose the homestead. I know that. And I remember going down to the property appraiser's office and talking to one of the exemptions officers there, and she explained it to me at the time, and it made sense then. I do not remember her explanation now, Jeff. So I would tell you this. Okay. Call the county in which you're residing. Are you staying within the same county, or are you moving county to county?
Moving to a different county.
Okay, so you're going to talk to both exemptions officers. You want to talk to the head exemptions officer in the county where you're located and the head exemptions officer in the county where you're destined for. And you want to make sure that that's coordinated, okay, that they know you're transferring the homestead from one property to another. And I think that's how I did it. And that was the way it was as seamless as possible. So you sort of give notice to one county, we're giving up the homestead here, but at the same time, we're not just giving it up, we're moving it over here. So there's coordination between the two.
So in the end, if I move and I go to a new home, I may not be paying what the buyer that would be coming in that didn't have an exemption would be paying. I may get some kind of reduction.
Right.
Right?
It's possible. So, and again, they'll tell you, I mean, my argument was this. The home I was selling was significantly less in value. And I said, well, since I'm paying these property taxes on that home, I should be paying the same property taxes on this new home, which was much larger and much more expensive. And, you know, the property appraiser and the exemptions officer look at me and they say, that's a cute argument. That's not how it works. But it worked for me. And
okay, well, that's what we're thinking.
Yeah, it didn't work for them. There's some sort of calculation they will do where they will give you a credit and apply it towards the new property. But there's a formula. They'll explain it to you and how it works and make sure you understand what kind of credit you are getting for having a prior homestead, okay?
Okay. Well, thank you, Mr. Smith. I appreciate it.
You're welcome, Jeff. Good luck with the move, okay?
Thank you, sir. Bye-bye.
You're welcome. All right, you're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. 877-943-9673, 877-943-9673. Reach us at the law office during the week, 877-754-6764. Again, that toll-free office number to schedule your complimentary consultation. Sun City Center or Seminole, Florida, or beautiful Tampa, 877-754-6764. You can always email your questions, patrick@attorneypatricksmith.com. Speaking of Clearwater, let's go back to Clearwater and let's talk to John. John, welcome to the attorney.
Yeah.
Oh, yeah, go ahead, John.
Hello.
Yes, John.
So I've got a question. My wife and I own a small business in Clearwater, and we've rented a building for probably somewhere around 8 or 9 years now. And the building owner is getting up there in age, elderly, and we had mentioned that if he ever wants to sell the building, we'd like to buy it. And a couple of years ago, he said, we could probably work something out where I could sell you the building and he would hold the loan even and that kind of thing. But then he came back and said he couldn't do it because he was going to be faced with capital gains if he sold the building. So I'm wondering, is there a way to arrange it where he can sell us the building and avoid the capital gains somehow? And,
It's a great question. I know if you inherited the building from him, there's currently a potential step up in tax basis. So the question is, how do I purchase now the right to inherit later? That would be sort of the estate planning gymnastics we would have to pull off. So you would basically, I'm trying to think if it would be some sort of right of first refusal you would be buying. So you pay $1,000 for a right of first refusal. I don't know. I mean,
Okay.
I think
So-
that's where we would have to get creative, is find some way to get basis adjustment to apply upon his passing still, because if you do a straight purchase now, obviously there's going to be a capital gains issue. So how do we play with that? And I don't know. I think we bring in a good CPA. I work with several throughout the state. Some of the best are right here. And I think it's a conversation we have where we say, look, this is the problem. What are our potential solutions? There are always solutions to these situations, John. The question is, how palatable are they to the individual client? And I think that's a matter of, some solutions may be more palatable to you, some will be more palatable to the property owner. And if you can find one that is mutually agreeable, I think that's the one you go with. But I think it's possible. I think you just have to get creative.
Okay. Yeah. When you mentioned the right of first refusal, when we rewrote the last lease, we actually wrote something to that effect in it, because he has some children that are adults that they're not interested in being a landlord for this property either. And we really don't want to make a real estate deal with them upon his passing if we can help it. So we did write something into the lease. I don't remember the exact wording, though, for a right of first refusal upon his passing.
Yeah, the ROFR sounds like it's headed in the right direction, but again, feel free to make an appointment. We'll review everything with you and see what kind of possible plans and paths to success we can come up with.
All right, great. Thank you.
Thank you, John. All righty, this is the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. Give us a call now, 877-943-9673, or call us at the office during the week, 877-754-6764. Email me, patrick@attorneypatricksmith.com. All righty, let's go to Tampa, Florida, and talk to Elizabeth. Elizabeth, welcome to the Attorney Patrick Smith Show.
Oh, good morning, Patrick.
Good morning, Elizabeth.
Yeah, this is just a little bit off your homestead subject and things, but how do you get an eccentric mother who's 85? I'm going to get upset, but 5 siblings, and we've been really trying to get her to just, get what she needs to have done, because there's 5 siblings, and she's somewhat eccentric. She's 100%, on the ball about everything, but in her mind, she just feels that I had a will done in 1970 when you kids were children, and she believes that that's still true. And I'm like, you have to have a will, you need a living will, you have to get this stuff together. And this has been going on she's 85.
Well,
and it's just, how do you entice her? Like, I just want to get her in, and you're the person I'm trying to get her to get into, and it's just, how do you? I mean, I don't know if it's an elderly thing where they feel that if that they're giving things away when they're still alive, but I'm like, you got 5 kids here who think, view things differently.
Yeah, Elizabeth,
So.
I can hear the stress and anxiety in your voice. I'll say a prayer for you, and I would say this: make me the bad guy. When you talk to your mom next, I would just say, look, I heard this attorney talking, and he talked like a lot of things have changed since the 70s. I think it'd be wise that you get it reviewed, and maybe that'll jar her loose. But Elizabeth, I'm so sorry. I'm going to give out the office number. You can feel free to call me. I'm coming up here on the show. So just give me a call at the office next week, and I'll be happy to talk to you and get you all the help we can. Okay.
I'll do my best to get her on in there.
All righty, Elizabeth.
I enjoy your show.
Thank you for listening. I appreciate it. God bless you and your mother. You're in our thoughts and prayers, okay?
Yep, thank you.
All righty. All right, let's go to Brandon and talk to Renee. Renee, welcome to the Attorney Patrick Smith Show.
Good morning, Attorney Patrick. I have a question for you concerning my mother's property. She has 10 acres out in a rural area, and we have step family that when their father died, they bought their own land not too far from my mother's property, and somehow they've attached their name to my mother's address, and we are receiving their property tax bills to our house. And I've tried to straighten this out through the county, and now we're still getting their property tax bills to send to my mother's address with their name on it. And I'm wondering if somewhere down the road, since this has been going on for years, are they going to be able to lay claim to the property because their name is attached to the address? I think the folio numbers are different, if they even have one. I don't know why they've chose to have their property tax stuff attached to my mother's property address. But several years ago, they obtained a loan through a bank and used my mother's property address as collateral.
Yeah, that you know, at the bottom of your tax notice, it says something about if you have a dispute or want to be heard on disputing, or you have a request for a hearing with the county.
Right.
I would follow that procedure, and I would.
Okay,
Get
I actually took my mom downtown one time to the building up, several floors up, and this was like.
Yeah, I would actually go through the formal process described on the actual statement and kind of say, look, we just want to get this rooted out once and for all. So I think that would be the best advice I could give you, Renee, okay?
All right, thank you so much.
You're welcome. All right, you're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. Thank you to all of you who called in today. And the office number to reach us during the week, 877-754-6764. Again, I'm Attorney Patrick Smith. To schedule your complimentary consultation, 877-754-6764. Email me, patrick@attorneypatricksmith.com. Everyone have a wonderful weekend. God bless. Stay safe and go Gators.